Scott versus McCluskey.
Yes, Your Honor.
And each side will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes.
Thank you. May I approach?
Yes, please do.
Thank you. May it please the court, my name is Tom Houlihan. I'm here on behalf of the Scott family, and I would like to reserve 5 minutes for rebuttal. In this matter, Roger Scott was 59 years old. He was overweight. He had a history of high blood pressure, a prior heart catheterization. He went to his family practice doctor's office, complaining of new onset chest pain, intermittent chest pain. They documented new edema and a heart murmur. And essentially, with that presentation, he had all of the cardiac risk factors that even a non-physician can identify. His encounter was with a nurse practitioner. The nurse practitioner worked him up, went and talked to a physician. The physician told the nurse practitioner to send this gentleman to the emergency room for a quicker workup, but that information never reached Mr. Scott. And 40 hours later, he's found dead on the floor of his employer's workshop. The jury did find negligence against the defendants, Dr. Hensley Lewis and Aaron Peter Wolf, rather. But they did not find proximate cause, and this is despite the plaintiffs putting on evidence that if Roger Scott had been sent to the hospital, he would have still been in the hospital when whatever rapid decompensation happened to him. He would have been monitored. That monitoring would have detected whatever changes were necessary, and he would have had quick access to a cardiologist and a cath lab that could have treated him appropriately and saved his life. The plaintiffs put on 2 proximate cause experts. They testified both the standard of care and proximate cause. Charles Blatt's a cardiologist. He testified to a reasonable degree of medical certainty that Roger would have survived if he had been sent to the emergency room the evening of his encounter with the defendants. He would have been observed for at least 24 hours and subjected to likely other forms of testing, such as enzyme tests, a series of EKGs, a stress test, before he would have been released back home. He would not have been released back home without a serious cardiac issue being ruled out.
It seemed like everybody, and we haven't read the transcript yet, but it seemed like a lot of debate and argument related to a catheterization.
Right.
Why, obviously we'll be reading this and whatever evidence is presented is all we can consider, but ordinarily it's more of the first avenue of approach with a heart attack is the blood test, the EKG, enzyme testing and so forth. But it seemed like everybody was emphasizing, well, they wouldn't have done a catheterization right away.
Right, and that comes from some of the material that was presented at trial. There was a dispute as to what the experts were talking about, essentially. Were the plaintiff's experts suggesting that Mr. Scott needed to go in for an immediate heart catheterization based upon the picture that was presented at the family doctor's office? And really, that's essentially the argument that the defense made, is that there was no need for him to have an immediate heart catheterization, which is a tough word to say, based upon what the family doctor saw. But if you look at the plaintiff's expert testimony, for example, Dr. Blatt, at his video depo, which was filed as part of the transcript, pages 43 to 44, he didn't say that based upon what the family doctor's office saw, that Mr. Blatt should have been rushed in for a heart cath. What he said was, I would not necessarily, based upon his presentation, take this man immediately to the cath lab, but this may reflect the beginning of something. And that something is what should have been monitored over the next several hours in the hospital. So for the defendant to argue, both at the trial court and on appeal, that the plaintiff's experts were advocating that he have an immediate heart cath at the time he left the family physician's office, that's not exactly what the plaintiff's experts said. So from our perspective, the important point of the plaintiff's expert testimony, both Dr. Blatt and Dr. Singh, who testified that if Roger Scott had gone to the hospital, he would have been stabilized with fluids, monitored on cardiac rhythm disruptions, and he would have quick treatment available if his heart had a further event, is that evidence was in the record, stated to a reasonable degree of medical certainty, and it was not rebutted. There was no basis for a jury to come to its conclusion that proximate cause was not met here. The proximate cause standard in a failure to treat or diagnose case is whether, with with proper diagnosis and treatment, the patient probably would have survived. The only two witnesses that said anything about that were the plaintiff's experts, Blatt and Singh. There was no evidence stated to a reasonable degree of medical certainty or otherwise about Roger Scott's likelihood of survival, alternate causes of death, or his life expectancy expressed by any of the three defense experts. Those expert witnesses were standard of care witnesses. That's what they testified to. In the 9th District, the jury cannot ignore unrebutted evidence. It's the State ex rel. Rogers versus Elbert case. If a defendant does not present rebuttal evidence on a point, a judgment in the defendant's favor is against the manifest weight of the evidence. That's clear case law from this court. So the defendant had the obligation to rebut the proximate cause statements of Dr. Singh and Dr. Blatt with evidence, and they didn't do so. Beyond that, I don't have a whole lot more I can argue, because what I'm arguing is it's not in the record. It's hard to come up here and cite the things that demonstrate that there's nothing in the record. You're going to have to read the record and come to your own conclusions. But there is no evidence submitted by the defendants on the issue of proximate cause, on the issues of survivability, alternate causes of death, Roger's life expectancy, those things that we need to prove a proximate cause case. In this matter, the negligence verdict of the jury was well supported. It should not be disturbed. What we'd like the court to do is to come to the conclusion there was no evidence from which a jury could determine that plaintiffs failed to prove proximate cause, and remand with instructions for the trial court to grant plaintiffs J&OV, put on the order indicating the proximate cause was proved, and then remand with instructions to have a new trial on damages only. With that, I'll yield to my opponent and rebut what he has to say. Thank you.
Police Department. My name is Doug Leek. I'm here on behalf of the defendants, Appellees Dennis McCluskey, MD, and Associates, and Dr. Brenda Hensley. It is our position that the jury verdict should be affirmed because it is supported by competent and credible evidence. Simply put, the plaintiffs failed to meet their burden of proof on the requisite element of proximate cause. There's no doubt here that the trial court did not err in denying the motion for judgment notwithstanding the verdict, and did not abuse its discretion in denying the motion for new trial. With regard to their first assignment of error, which with regard to the motion J&OV, this court's review is to determine whether or not the trial court erred in denying the J&OV. The trial court's review must be construing the evidence most favorably, or most in favor of the non-moving party, whether or not reasonable minds could come to different conclusions against the non-moving party. Here, there is no doubt that reasonable minds could come to different conclusions with regard to the requisite element of proximate cause. The issue here is that the plaintiffs claim that had the patient been admitted or sent to the emergency room and admitted, that his death would have been prevented. There was ample rebuttable evidence here that there would have taken days to weeks to perform a cardiac workup to get to the ultimate heart catheterization.
Why do you have, that's what I'm not sure I'm understanding. And again, my caveat is I've not read the record. I'm not sure I understand why the whole issue was whether a catheterization was necessary. Because if you go to your doctor and you have symptoms of a heart attack, and they send you to an emergency room, to ER, standard operating procedure is not to have an immediate catheterization. It's to run more tests, blood work, stabilize a person, and make an educated decision as to what needs to be done at that point. Now, I don't know if that's in the record. I'm just saying from what I know, and I can't consider that. I can only consider what's in the record. Was that in the record?
Yes, let's start with their family physician expert, Dr. Singh, admitted that had the patient been sent to the emergency room, there would have been a series of tests, enzyme tests, stress tests, EKGs, a complete workup. And there was further evidence that this same condition occurred 9 years earlier with the patient, where the workup took almost 10 days to get to the heart catheterization that could have resolved the problem.
But see, that's where I'm having the disconnect. I'm still not understanding why we keep talking about a heart catheterization. If you had gone to the ER, and I'm not sure what the evidence was, but I assume the evidence was presented from your briefs, that the doctor told the nurse practitioner send him to ER. Okay.
Correct.
And that wasn't communicated. And
Correct.
that's why the jury found there was a breach of the standard of care.
Correct.
So he didn't go to ER, but I assume there was testimony as to why the doctor thought he should go to ER.
From the plaintiff's experts, yes. And here's the point.
Well,
is-
no. Why did the doctor say
Oh, I'm
he
sorry.
needed to go to ER? Why did your guy say he needed, or your woman or whoever? say
Well, that
he
was,
needed to go
that
to-
was the negligence aspect of the case, which they found was negligence. But-
Why though did they send him to ER?
Well, they did not send him to
Well,
ER.
why,
I see. Why did the
why
doctor
did they
suggest
recommend
that?
he go to ER? I know that was a screw up, they didn't send him to
Yes.
ER, but why,
And
why was he recommended to go to
And
ER?
the key is,
I just have to ask the right questions, I'm
right,
sorry.
for the same reason that an appointment was made for February 2nd with a cardiologist to do the workups that would have taken days to weeks, and that's the point, is that the plaintiffs had to prove that there should have been something so immediately done at the emergency room that it would have saved this man's life in which he had
So-
passed away within 40 hours.
So your answer to my question was, your doctor testified that the only reason she was recommending he go to ER was to have workup done that would take days?
Days to weeks,
Then
yes.
why even referring to ER? Why not just referring to a cardiologist?
Well, that's what ultimately happened.
Well,
The
I
jury found.
understand.
Right, but
But obviously, she must have thought,
to get the workup started, in terms of, find out what the enzyme results were, and that's a key here.
well,
The
and
enzymes,
it was that, did she testify the reason was because time was of the essence? Because you usually don't send somebody to ER unless time is of the essence.
it wasn't that they said immediately, it was testified to that, it was a situation that could have meant going to the emergency room. But we still felt that sending the patient on February 2nd to the cardiologist was within the standard care, which the jury rejected.
Right, I understand that. So I'm just trying to figure out why the referral was made to ER. Or should have been made to ER.
Okay. Because the patient was in a family physician setting, and that they could have gotten to the emergency room, possibly seen someone. And also, there was testimony that the workup could have been done, not just be admit the patient, but to be outpatient. And for instance, stress tests, further EKGs. And the point of the defense was that time, in terms of the proximate cause, in light of all the evidence from Dr. Singh, and even their cardiology expert, Dr. Blatt, and our cardiology expert, Dr. Yakubov, was that it would take days to weeks to get to the treatment of a heart catheterization if needed. And our position here is that they never established, from a proximate cause standpoint, that what these tests would have shown, the enzymes, further EKGs, serial blood tests, stress tests, all those, no one established exactly what those would have revealed to get to the ultimate treatment of a heart catheterization.
Well,
And so that's where they
I've
lacked.
asked that question. Go ahead.
Is that the same as saying no one established that had he went to the emergency room, he would have been admitted?
There's no testimony there were different testimony in terms of that this could have been outpatient treatment or further testing also.
So no expert said, given what we know about this individual, had he walked across the street to the emergency room, if they were acting within the standard of care, he would have definitely been admitted. Was there any testimony about the likelihood of admitting him into the hospital?
Nothing definitive to that standpoint, because there was no testimony from their experts that established what the enzymes would have revealed that would have warranted inpatient
I
care and
thought your
treatment.
experts testified that he wouldn't have been admitted to the
No, I think
hospital.
they testified that, they generally testified that he would have survived. And what our defense was premised upon in terms of proximate cause was that was too vague of statements of the plaintiff's experts to say that they still had to prove what the cardiac enzymes would have revealed, what serial blood tests would have revealed, what
How would
EKGs.
they ever do that when he died? Is that ever possible? Could that have been done during the autopsy to say 48 hours earlier what your enzyme levels would have been?
This could have been, had they brought in a pathologist to testify to that, that could have been testified to and established had they brought in a pathologist.
Was there evidence?
But they did not bring a pathologist in to prove that.
What I'm asking you though is, was there evidence that you presented or anybody presented that could have been done? Or are we just surmising that? That a
The fact
pathologist
that,
would have had the ability to testify as to enzyme levels 48 hours before?
oh, I'm sure had a pathologist been retained, because there was no autopsy done, that could have reviewed, post-mortem, what it showed, and
That's
then
just
going
you
back.
surmising that.
But that was the plaintiffs had the responsibility, if they wanted to bring in a pathologist to go back in time and say, hey, this is what the enzymes would have shown on January 28th, 2004.
So there was no evidence about that period?
There's no
There was no
evidence.
evidence presented that a pathologist could have said that either?
Well, I think there was debate about, what the ultimate cause of death was, but we're saying it was an acute event, which it was not definitively determined other than a death certificate. And so our position would be that had they wanted to bring in a pathologist and then testify as to what that would have shown on the 28th, would have deemed, important enough to admit the patient further treatment, there's no evidence of that. So the only evidence is that both their two experts and our expert all agreed that there would have been a series of tests that would have taken days to even weeks after January 28th that could have post-dated January 30th when he passed away. And so during the workup, there was evidence that he could still have suffered this acute event on January 30th. And that was the proximate cause defense. And we did rebut their proximate cause theory.
And how did you do that?
We did it through the cross-examination of Dr. Singh, their cross-examination of Dr. Blatt, and then our own cardiology expert, Dr. Jacquelyn. And also we presented evidence and had everyone agree that this same situation happened with the patient when he was in Indiana, where a workup took 9 days, 10 days, to get to the ultimate treatment of a heart catheterization. And so it was reasonable for a jury to believe that that workup would have taken days to weeks past January 30th, the date of the decedent's death.
So you're saying your experts testified that this was an acute heart attack that could not have been predicted absent a heart catheterization?
Correct. And that time period, it would have taken us past January 30th of his death, that he could have been would have been in the midst of workups. We're talking about first getting the enzymes, repeat tests, serial blood tests, repeat EKGs, stress tests.
Of course, if you have enzymes that are off the charts and it's revealed that you are suffering a heart attack, you have treatment. You don't have to, even if you don't elect to have a catheterization, you can still have treatment for a heart attack without a catheterization even being performed.
But there was no evidence, once again, getting back to what a pathologist could have testified to, as to what those enzymes would have shown.
That's
On
maybe
that
the reason
day.
why the doctor went to the hospital.
That goes to the issue of negligence, which is not an issue here, it's the proximate cause. And it was their burden of proof to prove that element of what it would have shown, what the immediate treatment would have been had it shown that. But they did not present evidence, and what we were able to do was cross-examine their experts and present our own expert as to the time period that it would have taken for all these tests to ultimately get to the treatment if it was necessary, after all those tests. And that would have post-dated the decedent's death 40 hours later on January 30th. The key here is that there's enough evidence for reasonable minds to come to different conclusions with regard to the JMOV. And construing the evidence in favor of the defendants, the plaintiffs were not entitled to a judgment notwithstanding the verdict. Their second assignment of error deals with the motion for new trial based upon manifest weight of the evidence. And that's an abuse of discretion standard for this court. And the trial court did not abuse its discretion. And in a manifest weight of the evidence analysis, like their third assignment of error here, is that this court must presume that the jury, as the trier of fact, was correct in its findings. It is also necessary that this court find that the jury clearly lost its way.
I think we have to give any trier of fact some deference, but I don't know that we have to presume they were right. Why else would there be a weight of the evidence analysis?
Well, I think there's a
I mean, we
presumption
can find
that,
that they're incredible,
But-
that they could not have made that decision.
there's a presumption that the jury got it correctly because it's the jury that observes the witnesses, weighs the credibility of the witnesses, and weighs the evidence. They are the trier of fact. And the next step is, did the jury clearly lose its way or lose its way and create a manifest injustice here? And it did not. It weighed both plaintiff's case, defendant's case, and chose to believe the defendant's theory of proximate cause. And so the trial court did not abuse its discretion in denying the motion for new trial based upon manifest weight of the evidence. And I would like to address the fourth assignment of error that they had.
And counsel, I want to alert you too, that I know you have the cross assignment error, you have to address that if you want to now. I want to make sure you do that.
Okay, I'll get that. I don't think we're ever going to get to the cross assignment of error, but the fourth assignment of error is that their claim that the trial court abused its discretion in failing to give one jury interrogatory on standard of care negligence and proximate cause. But the trial court properly noticed that that procedure is not consistent with the Supreme Court case of Moretz versus Waukesha that says the jury interrogatories in medical negligence case is one on negligence, then a narrative, and then a proximate cause one. And according to the 10th District in Dillon versus Ohio Health, the 10th District found that negligence and proximate cause are independent of each other, and they can't be decided together, they have to be separate. We also maintain that they waived that error because on page 851 of the transcript, when asked if you have any objections, they said no. So our position is that the jury interrogatories were appropriate according to Moretz versus Waukesha. We don't believe you will get to the cross assignment of error because you will affirm this judgment. The cross assignment of error deals with the first trial where there was a defense verdict for nurse Erin Wolf. And the trial court then erroneously allowed her conduct to be tried again in the second trial. We believe that that first verdict was never challenged on appeal, that first verdict for Nurse Wolf and her conduct should have stand and should not have been an issue in the second trial.
Thank you, counsel.
Thank you.
Your time is up. Thank you. You have 5 minutes.
Thank you, Your Honor. Let me address that last point first with respect to the cross assignment of error. The court's prior opinion on this matter from the 2011 trial, paragraph 33 specifically says, further, on retrial, absent such a restriction, that the state may choose to present additional evidence against Dr. Hensley in an attempt to prove her negligence as an element of its wrongful death claims against both defendants. So the retrial was clearly contemplated against more than just the new party. I think as you examine that issue, you're going to find that the entire verdict was thrown out. It was remanded for proceedings consistent from the point that the error was made, which was the grant of summary judgment prior to trial, and the whole thing needed to be retried. So just briefly on that issue, that's really all I have to say about that. Now, what we just heard is that it was incumbent upon the plaintiffs to prove what the test results would have been if Mr. Scott had been sent to the emergency room. That's not the standard. The standard in the App.No case is whether, with proper diagnosis and treatment, the patient probably would have survived. What Dr. Blatt explained was, and this is at pages 47, 48 of his video depo, based upon both cardiac monitoring, enzyme testing, stress tests, et cetera, that he would have undergone a stress test, possibly with imaging, which would further clarify whether he had significant provable low blood flow to his heart muscle, and that would have really been a standard approach before allowing him to go home. If he developed leakage, the enzyme test, or if he developed a more prominent clear-cut ST segment elevation, that's an EKG, then he would have been gone immediately to a cardiac catheterization lab. So really, the important thing to take away from that is that he needed a further workup, and he needed it rapidly. If there was a significant event taking place, he would have had access to this treatment. All of this argument that's found on page 20 of the appellee's brief about the length of time that his first cardiac cath took in the 1990s is a completely different issue. It's explained by Dr. Blatt at page 71 of his video deposition that in the 1990s, Mr. Scott had a ST segment depression. The event that killed him, he had an ST segment elevation. Those are two very different things. Dr. Blatt explains it. I don't understand the distinction, but it's important to a medical practitioner. So all of this discussion about how long it would have taken for him to be worked up is really irrelevant, because the important point is, if the workup would have started the night that he went to his family practice doctors and they sent him to the hospital, that workup would have been done before he would have been allowed to go home. And if he had the event that killed him in the hospital, he would have had access to treatment. That's what our experts testified to. It was not rebutted, and that's why we should have the case reversed and remanded.
They say it is rebutted and that it was an acute episode that was not predictable and would not have been basically treated. And they've tried to get that point across cross-examination and through their experts.
What they cite on page 20 of their brief are 6 things. 2 of those 6 things are statements from the opening statements and the closing arguments, which is not evidence. With respect to the second one, Dr. Singh, they said he testified he could take a while before getting a heart cath. That's only true if he's outside of the hospital not being monitored and doesn't have an event. They say the same thing about Dr. Blatt, again. But if he was in the hospital, I just read to you what Dr. Blatt's testimony said, if he had changes, he would have immediate access to a heart cath. Dr. Yakubov, their expert, said it would take a long time before a heart cath was done. Again, outside of the hospital environment, that's potentially true. But even in his testimony, pages 681 and 682, he talks about what happens in his practice. If positive enzymes are detected or an EKG change is detected, I've already treated this patient with a stent or angioplasty, both of which are heart cath procedures. So even Dr. Yakubov's testimony that they cite to, their own expert, he says when those enzyme tests or EKG changes are detected, he goes in and does the heart cath, which is exactly what we're saying here. Roger would have been in the hospital when he had the event that killed him, going through this testing, he would have had treatment available to him. He lost that opportunity.
Would he have still been in the emergency room 48 hours later? He would have been admitted, would he?
Would have
not?
had to have been admitted, sure.
So there was testimony on behalf of the plaintiff that said if he presented at the emergency room the way he presented at the family doctor, had they not breached the standard of care, they would have admitted him?
Dr. Singh at pages 207 through 209 addressed that topic, and his testimony was Roger would have survived if he would have been sent to the emergency room.
Then they should have called the ambulance on the spot, shouldn't they?
Well, whether they call the ambulance or his wife drives him down the street, that wasn't really addressed.
That was Dr. Singh you just...
Dr. Singh, it's volume 2, pages 207 to 209. And Dr. Blatt also said essentially the same thing at pages 47 through 49 of his videotape deposition. So both of them testified if he would have been sent to the hospital, he would have survived this event.
And the counter evidence to that was, I don't know if he would have been admitted. That's the other side's argument, right? I mean, you're saying there is no counter evidence to that because that language wasn't used by their experts or by the testimony on the other side. But
well, the counter argument is that nobody on the other side stated that he would have died even if he went to the hospital, for example. Nobody addressed likelihood of survival, alternate causes of death, his life expectancy, or any of those issues. And
right, but I think if I'm understanding it, the counter argument to Dr. Singh saying he would have survived is Dr. Singh cannot say that because he's not premising it on enough information to say he would have been at the hospital when the acute event happened.
Okay.
I think that's the counter argument. And so the question becomes, is that enough to respond to plaintiff's evidence that he would have survived? Or does someone have to say he definitely would not have survived?
Well, Your Honor, in the Stenson case, the Ohio Supreme Court, any medical causative testimony must be, including alternative causes, must be expressed in terms of probability, irrespective of whether the proponent of the evidence bears the burden of persuasion with respect to the issue. So no matter who's putting on the evidence, plaintiff or defendant, it all has to be stated in terms of probability, medical certainty, medical probability. That's the Stenson case, syllabus 1.
And you need to wrap up.
I'm sorry, and there is no testimony of that sort in the record. Again, thank you for your time.
Thank you. The court will take the matter under advisement. A written opinion will be prepared and sent to both sides, as well as we'll release an electronic version on our website. Thank you. The court is adjourned.